Morning.
First case is State of Ohio versus Brittney Harris. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know as I'll be keeping track of the time. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the name of children, minors, or victims during your argument. You can refer to them by initials or terms like the child. We've read your briefs and we're prepared to proceed when you are.
Thank you, Your Honor. I'd like to reserve 5 minutes for rebuttal. And may it please the court, my name is Stephen Hanadel. I represent the appellant Brittney Harris. There's multiple parts of this, but I'm going to focus on the suppression motions that were filed in the early part of the case. And the first one attacked Ms. Harris's 2007 OVI conviction in Lorain Municipal Court because it was an uncounseled plea. And that's critical because this case represents her 6th OVI in 20 years, which then elevates it to a felony. And in the Ohio Supreme Court has held in State v. Brooke that an uncounseled plea does not count toward the priors. And therefore, her 2007 plea of guilty in the Lorain Municipal Court without a lawyer should not have counted toward the enhancement in this case, and therefore the degree should have stayed as a misdemeanor and not be elevated to a felony.
Would that be the defendant's burden to prove that it's uncounseled?
Well, the defendant actually has a prima facie showing. So according to Brooke, the Ohio Supreme Court said in Brooke in 2007, when the defendant presents a prima facie showing that the prior conviction were unconstitutional because they were uncounseled, in resulting in confinement, the burden shifts to the state to prove that the right to counsel is properly waived. Now,
so what was attached to the defendant's motion?
I didn't hear.
What was attached? Did she do an affidavit saying that it was uncounseled? What was her showing?
Well, there was a motion that was filed, but the trial court never held a hearing. And this is where this case gets a little weird.
The motion was filed with attachments or just the motion?
I don't recall off the top of my head, but I want to think that she did file an affidavit, but I can't recall. But there was a motion that attacked the 2007 conviction, and the judge did not hold a hearing.
I think the brief says there was an oral argument. Was that the hearing, or was it?
There was no evidentiary hearing. But where this gets strange is that in the judge's entry denying the suppression motion, he said that he reviewed the audio of the recording from the Lorain Municipal Court, which was then, when I was reviewing the record here in this appeal, there was no such thing in the record. I tracked that down into Lorain Municipal Court, which took quite a while for them to dig that up. So I'm just, given the efforts that it took on my part to procure that video and audio, that recording of the plea in 2007, I'm perplexed by how the judge was able to review that. But that's what he says in the entry, and I guess you have to presume regularity in that regard. But that recording is part of the record here, and so in that recording, it does show, yes, she pled guilty without a lawyer, and also I think the way she was steered into waiving her right to a lawyer and pleading guilty, I think presents problems, because it was clear in that hearing as an 18-year-old she did not know what to do in that arraignment. She showed up as she was supposed to do. Judge just asked her, well, how do you want to plea? And she was just standing there not quite sure what to do. And if I, recall correctly, there was, she's asked, do you want to waive right to a lawyer? And then there's a moment of silence. And it's hard for anybody, especially an 18-year-old, to just say no. And because you can pick up on the vibe coming from the judge. I mean, it's just a loaded question. And then she's asked, well, do you want to plead guilty? And and a long silence. I mean, she really doesn't know what to do.
So
And
wouldn't that video or audio plea be something that would be part of the defendant's initial burden to bring to the court? I mean,
Not
you're
necessarily.
arguing it right now as.
I get that, but not necessarily. I mean, I'm only arguing now because the trial judge said that he reviewed
I
it.
mean, even assuming that it isn't appropriate, wouldn't you have to, your client have to have met an initial burden and you could have.
Not necessarily with the video. I would say, I think in the motion itself is fine. That's where we get the State versus Guadalupe from the Ohio Supreme Court. You don't have to lay out everything in fine detail in the motion. And I would submit that not even an affidavit is necessary. I think the Ohio Supreme Court held in Guadalupe that you just gotta just provide the bare minimum facts that's sufficient to give the state notice and give the court notice of what's at issue here, and then, you know, and then based on what's laid out in the motion, it's one of those instances where the court, if you were to assume that's true, is there a suppressible issue? Then, you know, that's where the court, if the answer is yes, then the court should hold a hearing. And the trial court did not hold a hearing.
I'm trying to figure out what happened here with the hearing. So there's a reference to an oral argument on that first motion.
Sure.
Did the judge just say, I'm not taking evidence? Or did he
Yes.
say, here's your case, what do you have to say? And there was just legal arguments made? I mean, how did the judge preclude the defense from presenting any evidence?
He didn't hold an evidentiary hearing. That's just,
He just had a hearing?
he did not hold an evidentiary hearing. And he should have. I think there should have been an opportunity for Ms. Harris to take the stand, testify, and if there needed to be the procurement of the recording from Elyria Municipal Court, then fine. But as far as presenting the recording, I mean, that wouldn't be done, the recording would not be submitted with the motion. It would be submitted in the hearing in the courtroom and be admitted as evidence, as an exhibit. And then the judge would, you know, weigh it and make his decision. But that's not what happened here. It was just, there was no evidentiary hearing held. There was sufficient notice in the motion to apprise the trial court of what the issue is. But then the judge in the denial said, oh, I reviewed the recording, but there was no recording in the record. And so there's a lot of things there's some things that just don't make sense just from a common sense standpoint of doing this kind of work for quite a while now. But I have to at least take the record as is, and I have to presume regularity with the judge's journal entry. And so, you know, and track down the recording. But I think the recording helps Ms. Harris, and I think it bolsters her argument that a hearing should have been held, because the way she was questioned, the way she was guided through that arraignment, it was clear that she was not sure what to do and how to do and so on and so forth. And that's where a good trial court judge when in doubt, when you got a defendant up there without an attorney, and they're not quite sure what to do, and they're not quite fully understanding what's going on. When in doubt, you enter a not guilty plea and you appoint them an attorney. I mean, I've seen that done elsewhere in numerous other jurisdictions in practicing law, and that would have been the appropriate thing to do for the trial court judge, just to make sure that, hey, you're going to get an attorney who's going to give you the advice you need, and therefore you'll have the case proceed on its merits, and then they'll figure it out from there whether she pleads or goes to trial. But then there was also a second motion to suppress as well, and that regarded there was not a hearing held on that either, and I believe that's under my third assignment of error. And so that regarded this particular case with the traffic stop and the way that was handled. The judge didn't hold a hearing on that either. And again, in the denial, there was no acknowledgement that State versus Guadalupe even exists, even though that's a fairly recent decision by the Ohio Supreme Court, which was out of Lorain County, actually, from North Ridgeville. So it should have been known to the court here. And Guadalupe makes very clear that you don't have to write a full lengthy brief or a book in a suppression motion. You don't have to get into all this exquisite detail. You just got to provide the sufficient facts and law so that it apprises the court, apprises the state of what, hey, we got an issue here, and therefore it triggers a hearing.
So, in reading that motion, I see that there's a lot of law,
Mm-hmm.
and then or there's a recitation of facts that are alleged, and then there's a lot of law, but there doesn't seem to be analysis like this, any tie from the facts to the law. So do you think that's, if you haven't put the facts into an argument, or is that sufficient?
She laid out the facts, laid out the law. I don't think that that laying out a full-blown analysis like you would like an appellate brief is necessary in the suppression motion, because the facts haven't been developed yet in the hearing. I mean, she's alleging her side of the story, her set of facts. The state's going to have theirs, and that's where you got to have a hearing to develop the evidence and see, well, what is the truth, and then potentially if there is to be a post-hearing briefing, the court could call for that, and that's where I think a fuller analysis of applying the law to the facts would be warranted. But when you file a motion, when you're making the allegation to say, hey, this wasn't right, the state violated my constitutional rights, and you lay out the basic facts, that should be enough to trigger a hearing.
Because you can't prove a negative, is that what you're saying? Like, if you say this is the allegation, but there was no reason to stop, or are you saying that's enough because you're saying
there's got to be sufficient facts. Let's say hey, there was no reason to stop me, or there was no reason to suspect that I was impaired, so on and so forth, and lay out some sufficient facts as far as the stop and so on and so forth. But it doesn't require a full-blown analysis like you would like in an appellate brief, and that's what Guadalupe held, was that you don't have to overdo it in the motion. You can save all the effort for the hearing, so that people get on the stand, the defendant, the police officer, they get on the stand, they testify, and get the evidence out, and then go from there.
You have 3 minutes left. Do you want to reserve?
I'll reserve my time. Thank you.
Good morning, Your Honors, and may it please the court. My name is Spencer Luckwitz on behalf of the state of Ohio. I want to begin with answering a few of your questions, Judge Lassinger. Namely, the trial court did hold a hearing on the first motion to suppress. That hearing was held on February 11th of 2022. At that hearing, the state appeared, counsel for the defendant appeared, and the defendant herself appeared. The basis of that motion to suppress was, as Mr. Hannibal has stated, the question of whether her initial 2007 plea before Larry Moody was uncounseled. The only piece of evidence provided to the court at that time to support that the plea was uncounseled was a single affidavit provided by the defendant stating that she didn't have counsel when she made her plea in 2007. Further, to answer your question again, Judge Lassinger, you were absolutely correct. It is the defendant's prima facie burden to show that her plea was not only uncounseled, but that she did not validly waive that counsel. State v. Brooke in 2007 holds that once they've made that prima facie burden, they're able to then collaterally attack the plea. But I think that what's more important here is State v. Thompson, Ohio Supreme Court ruling of 2009, which specified that flawed allegations unsupported by any evidence does not meet the defendant's prima facie burden.
But counsel, in Thompson, there were no affidavits, and in this case, we have one affidavit. So what do we do about that?
Well, I think that we can view the affidavit the same way we would view it if she stood up on the stand and made a statement, right? Essentially, it's a sworn statement saying, I didn't have counsel. Clearly, I would like to point out there was evidence of a plea that occurred in 2007. The trial court was able to obtain it. Mr. Hannibal was able to obtain it, which means that her counsel prior to that plea, would have been able to obtain it through subpoena in the court. They failed to do so.
What about the issue that the ruling was made on an audio recording that obviously had to be sought out by the judge, and no one had the opportunity to argue about the audio recording?
Yeah, the trial court should not have relied upon it. That was improper.
Is that grounds for reversal here?
No. What the issue is that, and I think that Mr. Hennell said it very well, that wasn't on the record. You know, that was not put before the record of the trial court, which means that this court should consider that recording in making its determination. The only thing the trial court should consider is the argument made by defense counsel, by the state, and use those as its grounds to determine whether or not the prima facie burden was actually met. We hold it was not, because there was not actually any evidence shifting that burden from the defendant onto the state to show that it was validly waived. You know, I think that if there is an argument to make here, I don't want to make the defendant's argument, but any relief based on recording that would need to be sought would have to be through post-conviction, because it's evidence that was obtained that's not on the record. There is a way to attack that, to attack the determination of the trial court, but the way to do it isn't before this court. It's a motion before the trial court arguing for post-conviction relief.
Why can't it be on direct appeal?
Because it's not in the record, Judge.
Well, I know, but I don't want to misstate the appellant's argument, but I think the error is alleged that it was evidence outside the record relied on by the judge that didn't allow for argument, versus the videotape doesn't show what the judge says it shows, which would be a post-conviction type situation.
I think that based upon the arguments made by Mr. Hennell today, the proper remedy that this court should take is a determination based on what was provided to the court by the party. So it was properly placed before the trial court, and it should, seen as no one has disputed the facts that were alleged or no one has called into question credibility the facts that were alleged in the briefing and in the argument before the judge, the trial court. This court should be able to proceed under State v. Burnside, weigh that evidence, weigh that testimony, apply the law to it, and make a determination about whether or not the defendant met her burden and if the court should be reversed on that basis. I think that any consideration of the video is improper. Any consideration if there was a video that the defendant didn't bring to the court is also likewise improper. And I think that the court should hold that the reliance on the trial court in determining the argument on the basis of the video was improper. That does not mean, however, the defendant gets to redo the suppression hearing when it was her burden to bring that evidence to the court in the first place. Moving then to the Guadalupe issue, the issue of the second suppression, Criminal Rule 47 requires that the defendant state with particularity the grounds upon which the suppression motion is made. And the grounds on which the defendant, Ms. Harris, stated that the suppression was made was the tests of her coordination, sobriety, and alcohol level, her statements that she made to the police at some point, and the observations and opinions of the initial stopping officer. And I think this is concerning particularly for the first issue, because we see from the record of the trial that there were no tests made of her coordination. She refused any chemical tests. So for that instance alone, the state has no notice of what the actual tests that are sought to be suppressed are, because no tests were done. Further, I think that while Mr. Handel is right, it is a low burden. There does have to be some specificity, some statement made that there is indeed, or of what actually is being challenged. I think the 11th District said it great in State v. Osborne when they say that by alleging a violation of everything, the defendant is actually alleging a violation of nothing. It's not enough to simply stand up here and say, this was wrong. You have to say why it was wrong, how it was wrong, and how you think that there should be, and why you think there should be an evidentiary hearing into the matter. Why should the state have to come up here and prove to you that what they did in the probable cause stage was proper? Here we didn't have that. We had a bare recitation of facts. we had a large amount of law. I think that what's happened here is the defense counsel was trying to use the law to bolster their factual arguments.
So if you make so you allege the facts that, say in a motion, you allege, you do a recitation of the alleged facts, and then you get to the law part and you say there was no reason to stop the defendant, and the defendant in a previous text was stopped for a stop sign violation or something. It's just saying there was no reason to stop an argument? Because, I mean, I guess the next sentence would have to be there was no violation. I mean, would it have to go that far? I mean, where's the line? Where do you think the line is there?
Well, I think since, in a motion to suppress, we are dealing with probable cause. I do think that there has to be at some point, there has to be something to show that there would be a reason for the state to lack probable cause to effectuate a stop or to effectuate an arrest, as the case may be. Because I don't think that the motion to suppress challenged the stop. I think the motion to suppress only challenged the arrest of an OVI. Of course, I'm not entirely sure because there wasn't a lot of facts based on the record in the motion to suppress.
So if the motion shows in the facts section that she spoke to the police, and then later on at the end, like it does here, says her Miranda rights were violated because she was arrested, or because there was an arrest without Miranda, is that enough? Because you're saying these things just didn't happen.
Well, I think that would be a different scenario. I think that would be that point. That would be saying, well, did you Mirandize my client? In which case, that would be a requirement the state should be able to meet and approve. But here, again, I don't think that was actually an allegation in the motion to suppress. There was no allegation that she wasn't Mirandized. There was no allegation that she didn't, or that the officers didn't have probable cause. Just that this happened, and we think there were issues with it. We don't know quite what those issues are, so we want to suppress it. That's not enough. That can't be the basis for specificity under Criminal 47. That can't be the basis for specificity under Guadalupe. I think for those reasons, the trial court was right in dismissing the second suppression without a hearing. Mr. Hanno didn't get into it. If the court has no further questions about the sufficiency or manifest weight, I won't address it here. Seeing none, I think the state will rest on its briefs. Thank you, Your Honor.
Go ahead, 3 minutes.
Thank you. As far as with the video recording of the Leary Municipal Court arraignment hearing, the plea, the conundrum that I was in is that when I saw that the trial court judge had relied on this recording of not the record, if I were just to forge ahead with the brief and not track down that video, the potential problem that my client would run into is that this court could presume regularity with the record. And oftentimes if the record's got to get made before filing the brief, and so if once the briefing starts, then the record is set, and so the trap that my client would have headed into was, well, the trial court judge said he reviewed the record, and well, appellant, it's on you to make sure that the video is in the record or the recording's in the record. And so the burden is ultimately on the appellant to make sure that the record contains everything it's supposed to contain. And so, I wasn't trial counsel, so I wasn't there. So that's why I had to try to take it upon myself to, try to track down the recording. And then if I couldn't, then try to do everything I can to utilize Appellate Rule 9 as best I could. So, it is what it is right now. So I think the court can rely on the video and determine that, hey, this is something that the trial court should have held a hearing on, and get Ms. Harris's side of the story as far as what happened at the Leary Municipal Court hearing, when she walks in there by herself and then the judge is prepping her with questions like, well, do you want to plead? How do you want to plead? Well, do you want to waive an attorney? Do you want to plead guilty? I mean, it was clear that she didn't know what to do, and she eventually just decided to go along with the authority figure, as would anybody of that age would do, like any high school kid. You're in high school or just out of high school, I mean, they're going to tend to nod along with an authority figure, you know, except for maybe some who might defy the teachers, but it's just, that's generally, you know, when they're out of their, when they're in over their heads in terms of education and knowledge in a setting like, especially in a courtroom, you know, they're just trying to just get out of there as best they can, and they're just gonna kind of go along and go with the flow, and that's what she did. And the Elyria Municipal Court judge should have recognized that, you know, she didn't know what to do, should have said, all right, I'm just gonna enter a not guilty plea and appoint you an attorney, and we'll have a pretrial at a later date. I mean, I've seen that happen quite a few times in my experience practicing law.
So the judge is supposed to recognize some kind of vulnerability of
Yes.
a defendant and automatically enter a not guilty plea?
Yes,
Or
I
is there
think
just certain things he's supposed to make sure they understand?
well, to understand, but I think it was clear that she didn't fully understand what was
So
going on.
anybody who's 18 needs to be set for a pretrial and enter a not guilty plea? So they can
Well, I
talk to
think
the lawyer?
what I think the Elyria judge should have done was that enter a not guilty plea, appoint her an attorney, set the matter for a pretrial later, and that way she can have counsel to properly advise her on what to do about the case and go from there. And then it would proceed how it proceeds.
But
So-
counsel, just to follow up on Judge Lanzinger's question, so is that the rule that you're asking this court to develop, that if this situation, or is it just particular to your case?
I think, well, for starters, it would just be this particular case, but I think if the court, if it wanted to get into a grayer rule, I think it can. I mean, I think that is the appropriate practice that's consistent with the Ohio and United States constitutions. It's not that burdensome on a trial court, and I've seen, you know, again, I think of Judge Collier in Medina when you know, when there was a confused defendant in front of him, and he's asking questions, and the person that doesn't know what to do, and then he just says, all right, I'm just gonna not guilty plea, pointing to an attorney in the courtroom and said, here, you take this case and go from there. And I've seen that in other jurisdictions as well. And so that is ultimately the safe and appropriate thing to do, because you want to make sure before a defendant gets convicted, I think any judge has an obligation to make sure that their constitutional rights have been protected, their due process rights have been protected. And one can always feel better about a conviction when you know that there's not even the slightest hint that those basic fundamental rights of a right to an attorney and a right to a trial, that those were not unduly impinged.
And you're out of time, so
Okay.
if you'd like to wrap up.
Thank you.
You're welcome. Thank you both for your presentations. The court will take this matter under advisement and issue a ruling in due course. The clerk of courts will mail you a copy of the decision on the day it's released. Also, our opinions are posted on the Ohio Supreme Court website. Thank you again.